interesting. If anybody's in the food service industry, yeah, this is kind of cool. This is new. Remember how you go to restaurants? You go to restaurants sometimes, and if you have like 8 or more people, they put a service charge in. They build the tip right in. Well, the IRS now, effective this year, says that's wages. So if you own a restaurant, food service where there are tips, and you put a service charge in there, that is now considered wages for purposes of withholding, for purposes of figuring out their overtime rate of pay. That's not a tip. Tips are treated differently. Tips are not part of their wage. All right? So to be a tip, you have to be free from compulsion. The customer must have the unrestricted right to put whatever amount they want, and the customer has to be able to say who the tip goes to. And so service charges aren't that way. So if you have any kind of business where you have 8 or more people you're serving or whatever it is, we're going to build in a service charge, that is a wage. And you've got to calculate their overtime and stuff. You've got to add that into their wages. It's not a tip. Interesting, huh? So a lot of companies now are just having suggested, right? They say, 15%, 18%, 20%, and you just write in the amount you want. But it's not, you can choose what you want. Yeah?
We have like an agreement with the IRS that they came in years ago and figured what the average tip percentage was, where before you had, somehow it was 8%. So anyway, they figured it out. I think in our case it's like 10%. And so we have an agreement that they won't audit us and they won't audit our employees by using that figure that they have agreed on.
Well, however...
Is that an exemption to this?
No. The fact that the IRS says we won't audit you means nothing. Okay? It means nothing. Unless Obama signed the order, it's not going to mean anything. So this is a little bit different. So if you do have the built-in tip, that the customer has no choice, it's just built in, that you calculate as a wage. So you're better off not even doing that and maybe just giving the suggested tip levels. Because this is kind of a different issue, whether it's a tip or a wage. Not how you calculate the average tips. It's interesting. Go figure. Okay. Oh, so this is, we talked about this before, GINA, the Genetic Information Non-Disclosure Act. You're not allowed as an employer to find out any information about anybody's genetic predispositions, genetic backgrounds. Okay? That's not, you can't search for it online. That's one of the reasons we recommend you don't look at Facebook before you hire somebody, because you might find out they're part of a diabetes association group or something like that, and they'll find out you looked at it and then use that as a reason not to hire them. So you can't get any information. And this was an interesting case where they sent people to pre-hire drug testing things, pre-hire physical examinations. You can do that. This company, reputable company, gave them a questionnaire, the person. A lot of questionnaires have family history on it. Well, that violated the law. Family history asks, your parents die of a heart attack or this or that, you have a history of cancer in your family, and this person, the EEOC, got involved. The first case, this law's been around for a while, but this is the first case, and the company settled for $50,000. Because they said, well, we didn't ask, our company asked that we hired, but they were your agent. So if you're going to have medical exams before you hire people, make sure they understand the GINA rules. Okay, very important. And you could see how an employer could kind of get into a mess with this because, before, you're walking down the hall and you see one of your employees and you say, oh, how you doing? And they go, oh, I'm not doing too well. And you say, oh, why? Well, I don't know, I had this liver issue, my mom had it, and I'm going for tests. But now you just violated the law. Okay, because now you found out about some genetic stuff. So my advice, going forward, you're walking down the hall, employees, oh, hi, how you doing? The employee says, not doing too well. You say, I don't care. That's your lawyer's advice. Once you know about it, you're violating the law. You're not supposed to do anything. If employees are talking about something and you overhear it, it could be a potential violation. You got to just ignore it, not think about it, not talk about it, not ask about it. Okay? Funny. So go figure. All right. Okay, this is back on the agenda. This is this is interesting. Again, this is a big area. Misclassifying employees, independent contractors. The federal government, there's a new, the Senate bill Who knows if it'll pass? There's not much getting done, but they bring this back every other couple of years, the Payroll Fraud Prevention Act. This now is going to require all employers to give employees and a category of people called non-employees, meaning your independent contractors, a notice that says you're an employee or you're not an employee, and a description of the website you go on to, Department of Labor, where you can check to see if you are or not, and you can inquire whether you are or not. And you got to give them the special notice. Okay, you have to do that. Failure to give the notice, piece of paper, the person will be presumed to be an employee. Presumed. That you can only defeat by clear and convincing evidence. In most cases, all you need to show is a preponderance of the evidence, which is 51%. Clear and convincing evidence is 75%. It's just the standard. So it's much harder to try to show they're an independent contractor if you don't give them the notice. Plus, failure to give the notice is a $1,100 fine and $5,000 for every subsequent time you don't give a notice. So far it hasn't passed. It's coming. If it does, we'll have to talk about it in our 2015 law update, and you'll see. So watch that. That's a big area where the feds are concerned about, because independent contractors, you're not paying all the taxes, hiding the money. Much easier with payroll to track what the taxes are, the FICA, all that coming in. Okay, and this is also interesting. We get questions all the time, and we work with accountants on this too, is when you give a severance pay, remember you're going to terminate somebody, and often we recommend, if you're concerned this employee is going to sue, they've been troubled, they've caused a lot of grief, you may want to give a severance. And if you give a severance, you always want to have an agreement. Because just giving them extra severance without an agreement is not a good idea. So the severance agreement says, you're never going to sue us, or you can't. You waive all your rights. They still can file claims with the government, but they can't sue you. Okay, they can waive all their rights in there. So the question is, do you take out, is it run through payroll or not? Running through payroll costs the employer money, doesn't it? If you're going to give a $25,000 severance, you're going to pay 6.2% FICA. That comes out of your pocket as an employer. We generally say run it through payroll. But this has become such an issue, and there's a division among the circuits in this country, that the U.S. Supreme Court is deciding, for FICA purposes, whether you have to, pay its wage or not. So that would save you 6.2%. So that's your half of the FICA. So we'll have to see how that comes out, Supreme Court. So check with your accountants. Think about that if you're going to be making severance payments, because it could save you some money. Okay, so now I think Ted's going to be doing the next.
Yeah. So what happens if you do fire an employee and you have all kinds of great reasons why this employee deserved to be fired, but there was also kind of a bad reason that you kind of knew about, but that really wasn't the reason I fired her? Well, that's called in California a mixed motive case. And there was a really kind of a landmark, huge case that came out last year dealing with what do we do in a mixed motive case. Good reasons to fire, bad reasons to fire. Well, we now know how that case is going to play out. This is the case Harris versus City of Santa Monica. This woman, Harris, was hired as a bus driver for the City of Santa Monica. During her probationary period, she had 2 accidents that they ruled were entirely preventable, and she had several no-shows on the job. Seems pretty compelling that this person's probably not going to make it past her probationary period. Well, and here's where it comes, the problem where it comes in with timing. The day that the supervisor received the list from management as to which probationary drivers did not make the cut was the same day that this woman came in and told her supervisor that she was pregnant and she needed time off. Well, and of course, according to her, the supervisor was, in her words, displeased that I was announcing my pregnancy and asking for time off. Well, but unfortunately, he also got the list of, here are the employees who didn't pass probation. And she, of course, was on the list. 4 days after she told her supervisor she was pregnant, she was fired. Well, this obviously looks bad. So she sued, And here's what the court decided. First, the employee has the burden of showing that the illegal reason, the pregnancy, was a substantial motivating factor in her termination. If the employee can show that the pregnancy was a substantial motivating factor, and that's pretty easy to show that because, well, it happened within a day after I said I was pregnant, he looked displeased, he grumbled, he demanded a doctor's note, which of course is within his rights. So she was able to show that, well, my pregnancy was a motivating factor. Well, the employer, in this case the city of Santa Monica, was able to avoid some liability by proving that there was a legitimate reason for the termination. The legitimate reason or reasons would have led to her termination regardless of the pregnancy. She's had 2 accidents. She didn't show up for work. And this one's a little tricky, that the city was motivated, in fact, by the legitimate reasons. Not really sure how you show that. But again, documentation. That's your evidence. If, and in this case, the city was able to show those things, their damages were reduced significantly. The city was not liable for any monetary damages. The city was not liable for any back pay. And the court is prohibited from ordering reinstatement. So good. Wow, what a win for the city. Well, not quite. Employers are still liable, again, if the employee is able to show that the illegitimate reason was a motivating factor. The employer is still liable for a really bad one, attorney's fees, and potentially an injunction saying, well, you can't ever do this again. Well, the attorney's fees is really the bad one. So, and the court reasoned that, well, you know, we want to give the employer a break here because there were obviously legitimate reasons for this woman to be fired. But we really are sending a very loud and clear message that discrimination, and in this case pregnancy discrimination, is absolutely prohibited and a very bad thing. So we're going to still hit you with with paying for her attorney's fees. So it's kind of a win, but a kind of a mild win. Yes.
They didn't have anything about the incident, the driving incident?
No, of course, and that's why the city won. The city won. She was not entitled to back pay. She was not entitled to any of the other damages that you normally get, because the city did show that there were legitimate reasons for her to be fired. But because the supervisor showed a displeased look, and it happened within a day after she said she was pregnant, it also led to the inference that there was some illegal discrimination there, so they had to pay for the attorney's fees.
Are the attorney's fees based on a kind of private attorney general recovery?
No.
Or are they...
The actual attorney's fees, I mean, now the courts use different formulas because to make sure that they're not out of line. But if they're reasonable attorney's fees, yes, they have to pay those.
And the attorney sort of can agree to whatever arrangements they can mutually come to.
Yes. So that's an important one. Again, document. Watch out for the timing. Optics. In this case, maybe they should have waited a little longer than a couple days before firing her after she said she was pregnant. But it's a tough one. It really puts the employer in a pickle. This lady's causing bus crashes. I mean, what do you do? So I'm sure obviously everyone's heard of these cases. These are the 2 biggies that happened last year dealing with same-sex spouses. U.S. versus Windsor, which the U.S. Supreme Court struck down the Defense of Marriage Act. So that's on a federal level. And then at the state level, we had the case overturning Proposition 8. So what does that mean for employers? What that means for employers is a couple things. Now, employees with same-sex partners are allowed to take FMLA, as well as CFRA. They were always able to do CFRA in California, but now, because DOMA has been struck down, FMLA is now available to employees to care for a same-sex partner, a spouse. Registered domestic partners are not covered by FMLA, but they are covered by CFRA. So another tricky one to watch out for. And again, this old FMLA, which is the Family Medical Leave Act, and the CFRA, the California Family Rights Act, they only apply to employers with 50 or more employees. So again, this is the consequence of striking down DOMA. If the employer pays for the employee's spouse's health insurance, sometimes you cover dependents' health insurance. That used to be wages to the employee if it was a same-sex marriage. Now, if it's a same-sex marriage, that benefit is no longer considered a wage. And then, of course, health savings accounts. Sometimes people have HSAs. That money is now available to care for the same-sex spouse of your employee. So those are just some little differences that affect employers now because of these cases. So watch out for that. And another tricky thing is before there may have been you may have had an employee with a registered domestic partner of the same sex, and that's not treated the same as a spouse. But now maybe they're married, and really the employer has no way of knowing that. So, and you can't ask. So it's an area that you have to be a little bit careful in when someone asks for time off to take care of a significant other, even if it's the same sex. They may be entitled to all the protections. NLRB. So last year at our 2012 update, we spent a lot of time talking about all these crazy things that the NLRB is up to. The NLRB has been targeting employee expression restrictions, employers putting restrictions on their employees' right to express themselves. A lot of times in your handbook you may say, you cannot make disparaging remarks about the company or your supervisor. Well, the NLRB has struck down all those. A lot of lawsuits about that, saying you can't put that in your handbook. Well, now all that is up in the air. All these slew of cases where people were fired for disparaging their supervisors, that's going to be up in the air because the NLRB was composed of members that Obama appointed while the Senate was in recess. And there has been this lawsuit saying that those recess appointments were illegal. And the U.S. Supreme Court is now going to hear that case and to determine whether the recess appointments were valid. If the recess appointments were not valid, then all this stuff about the NLRB might be going away. So, for example, the NLRB recently targeted and sued an employer because that employer had a policy that said that you have to be respectful. Well, the NLRB said, no. An employee has the right to be upset, to talk to his other employees about his working conditions, the terms and conditions of his employment, and he doesn't have to be respectful. So we'll see if the NLRB is going to still be able to do all those things. Under the CFRA, this is an interesting case. This was a case where an employer had an employee out on CFRA medical leave. The employer saw this same employee working at his restaurant. The employer fired the employee for violating CFRA. And he lost because he didn't have a detailed job description. Maybe the employee was disabled and needed that medical leave for purposes of performing his job with you, but he may have been perfectly fine to flip burgers at his restaurant. So even though the employer had what was called the honest belief that this employee was violating CFRA, he could not fire him. and he lost for firing him. I mean, you'd have to really have a lot of evidence, like if this employee was out bowling and you caught it on video and he's jumping around and, maybe then you could fire for violating the CFRA leave. But just because he saw him working somewhere else, well, the job descriptions are different. This is another interesting one. This kind of ties back in with, yes? The California Family Rights Act. So then you've got this case. We talked about all these disabilities, the ADA, the mental disabilities particularly. And let's say you have an employee who has one of these disabilities and you provide reasonable accommodation. Maybe she doesn't have to come in to work all the time. Maybe she gets to take time off. Maybe she gets to come in late to deal with her disability. Well, the other employees are going to be like, well, what the heck, man? Why is she getting all this special treatment? And the employer is going to be very tempted to say, well, she's got bipolar. She's crazy. So don't do that. Okay, I mean, it seems obvious, but if you're in that situation where an employee is getting special treatment and now morale is down because everyone else thinks, why is she getting all this special treatment? You're going to be very tempted to say, well, it's because of her disability. You can't say that. This was a case, Yum Brands was sued. Yum Brands is KFC and I think Taco Bell and a number of other fast food chains. And they had this exact situation where a supervisor verbally, and the law used to be that it had to be in writing. Now it's verbally told other employees in the restaurant that that this other employee who was receiving accommodations had bipolar. Well, that's an invasion of privacy, and they lost big time. So watch out for that. Oral disclosure of that fact is liability. So this is another one that I'm sure everyone's aware of. New minimum wage. New minimum wage. $9 an hour now, and in 2016 it's going to be $10 an hour. On top of this, there's a new law just this year that now says that in addition to all the other penalties and violations that you're going to face for not paying someone minimum wage, there is liquidated damages. So what that means, just as an example, if you don't pay an employee for 1 hour of overtime, let's say an employee works 9 hours, for whatever reason, they were misclassified as exempt or you didn't pay the overtime, in 2016, when this becomes $10 an hour, you will owe that employee $25 per hour of missed. And then you can see how fast that could add up if you have multiple employees, and most times it's not just 1 hour that you violate the overtime, it's many hours. $25 an hour, that's because it's 1.5 times the regular wage for overtime, so that's $15, and then $10, which is the minimum wage, in liquidated damages. That's the new liquidated damages. So that's $25 per hour that you screwed up. That could add up very quickly. So watch out for minimum wage. Now, most people don't really think about the other piece of what does minimum wage affect exempt employees. And this is going to open up floodgates for litigation, this new increase. There are two parts to the exempt employee test. And exempt means you don't have to pay an employee overtime. Everyone's aware of that. There's the duties test. We always talk about the duties test. You know, executive exemption, administrative exemption, they're a supervisor, all these things we have to look at to see if they are exempt because of the duties that they are performing. But there's also something called the salary test. In order to be an exempt employee in California, you have to earn 2 times the minimum wage. Well, now that the minimum wage has gone up, that means you have to be paid $27.73 per month. That was what it was before. Now it's $31.20 a month. So if you have an exempt employee that you pay a salary to and you don't pay overtime, they have to be making at least $3,100 a month. And in 2010, that goes up to $34.66 a month. So if you don't pass the salary part of the test, even if this person is a supervisor, clearly a supervisor qualifies for the exemption, If they're not making 2 times minimum wage, they lose the exemption. And you've got all the overtime and the penalties and everything else. So watch out for that. It's a very big area of litigation when minimum wage is increased. Yes?
So as a non-profit, when you hire somebody to do your website, how do you read through the nuances of this? Because you're probably not paying them enough to make the salary category.
Well, they're probably not exempt anyway. If it's just someone that you've hired to be a website person, that person is probably an hourly employee anyway. So you just have to make sure you're paying him minimum wage. However, which is now $9 an hour. However, if that website designer is more of a computer professional, a computer software professional, well, you have to pay way more than minimum wage. Those numbers have all gone up. For computer software professionals, doctors, and particularly those 2 categories, they have a very special minimum wage. And a computer software professional isn't just your IT person that comes and fixes the server. I think this is more of someone who's programming for you. They will be required, if you're going to treat that person as exempt, to be making this much, $84,000 a year. That's the minimum wage for a software professional. And a physician has a minimum wage of $73.57 an hour. So watch out for those. So the minimum wage is more than just watching the minimum hourly rate. There's more to it.
CPA or accountant in that category?
No, CPAs, I don't think CPAs have a special, they're just minimum wage. Personal attendants. So this is a really tricky area, and it's becoming a more and more common area as people have elderly parents. You have your elderly parents, and you want to hire someone to take care of them. Well, do I have to pay that person, that caregiver, minimum wage and overtime and all these other things? Well, maybe. Personal attendants are exempt from overtime, but they are not exempt from minimum wage. So what is a personal attendant? This is a tricky one. A personal attendant is someone who provides care to a person who is either a child or a senior who needs help, feeding, bathing, dressing. That is a personal attendant. And if that's all they do for 80% of their time is feeding, dressing, bathing, caring for this elderly person, then they qualify as a personal attendant and they are exempt from overtime. You still have to pay minimum wage, but they're exempt from overtime. However, if this person falls over into becoming what's called a domestic worker, 2014, we have a brand new thing called the Domestic Workers Bill of Rights. What this means is that if you are both a personal attendant and a domestic worker, which means you also clean the house, maybe do some gardening, maybe do some shopping. If you also do those things, well, now you're not a personal attendant anymore, you're a domestic worker. So you got to be very careful about the job duties that you assign to this person to come in and care for your aging parent or grandparent. Because domestic workers are subject to overtime. They do get overtime. It's a little different of an overtime, though. This is where it's even trickier. Normally, overtime is any hours worked over 8 in a day or 40 in a week. A domestic worker is entitled to overtime if they work more than 9 hours in a day or 45 hours in a week. That's different. Still subject to the minimum wage, of course. Now, this law is set with a 3-year sunset. So it does expire in 2017. It's kind of an experiment. I think they're trying to protect housekeepers and gardeners and people of that nature from being taken advantage of, and they're going to see how this works out. It does not apply to casual babysitters. So if you have someone who comes in as a casual babysitter who just watches your kids once in a while, they're not considered a domestic worker. But that's pretty much it. And this obviously does not include people who work in a facility taking care of, I figured that's where you were going with your question. If you work in a facility taking care of elderly people like a nursing home, that's not, these are for people who live in or work in a private home.
I think to follow up a little bit what Ted said on that mixed motive case where the employee got nothing but the lawyers got their attorney's fees, keep in mind that almost all of these employment law cases are lawyer-driven. That's who comes out on this thing. Most of the time, the employee's damages are not that much. I mean, you didn't pay overtime a little bit. You retaliated. They found another job. I mean, it's in the few thousands. $5, $10, $15, maybe $20,000. But the lawyers get tons of money, and the lawyer didn't care that this employee got nothing because it's got his attorney's fees. And they get their attorney's fees. They submit their $500, $600 an hour, and they'll have put in several hundred hours on that case, and you're going to get a $300,000, $400,000 bill that you got to pay. So it's all driven by the lawyers. That's one of the reasons we really, when this happens, we try to settle. Even if you're right, you try to settle quickly because the less time the lawyer puts in it, the more they make. So you've got to keep that in mind. It's so bad. Also, people had questions here about what CFRA is and things like that. We do quarterly lunch and learn, so you're now all going to be on, if you're not, you're all going to be on our mailing list. Most of you are, where we have, we provide lunch and we talk about independent contractor versus employees, what all the leave rights are, what are the exemptions for exempt and non-exempt. So we have these continuing programs. So you'll get that, you'll come and you'll be able to learn. And if there are things you'd like to hear, specifically let us know. Also, I want to remind you that we have like an evaluation sheet on the bottom of your stuff there. So please fill that out when we're done, and then write in if you'd like to hear about anything else or the topics, and we'd appreciate the feedback. We like that. This is new. If you're in the agriculture, construction business, landscaping business, irrigations, oil and gas, anything where you work outside, where your employees work outside, we have California industrial safety orders. We have Cal-OSHA regulations that deal with heat. We already have laws that say if it's over 85 degrees, you have to provide shade. Shade that covers at least 25% of the employees working outside where they can sit in the shade. Now, if it's hot and it's 85 degrees, it's not necessarily the magic number. But if an employee feels that they are hot and they need to have a cool-down recovery period, you must allow them a cool-down recovery period of at least 5 minutes, or as long as that employee feels he or she needs. And you have to offer it, apparently, as much as they want. So they work a half an hour and they want to sit down for 15 minutes in the shade. They need a cool down. There's no real definition for this. They need to rest. And if you fail to provide that, you say, no, I want you to keep working, then you owe them an hour of pay for every time you deny them that 5-minute rest. That's the penalty. And if they need 7 minutes or 8 minutes, they get it. Well, that's the new law. We don't know how that's going to play out in people in those industries. So again, job description, we're going to be working 80-degree, 90-degree, 100-degree weather, for 3 hours at a time. Put that down. I'm not going to supersede this law, but at least you have some argument that that's the job description, they knew it. I mean, if they can't work more than 2 minutes in the heat, and they got to sit down for an hour, obviously they can't do the job. But you got to be very attuned if you have any kind of outside labor, which is kind of interesting. You work outside. Kind of interesting. Government, again, California, we want to protect low-wage employees, often immigrants, from what we call wage theft, where you don't pay them the full amount. You don't pay them minimum wage. You pay them less than they're entitled to, and you kind of treat them badly. Well, if an employee makes a complaint, orally or in writing, that, hey, I think I'm owed some more wages, and you take any retaliation, any kind of adverse action against that employee, they have an action. They can sue you for retaliation. There's also a civil penalty that the labor commissioner or the courts can impose of $10,000 per employee. So again, if some employee says, I think you didn't pay me overtime, and a month later they're fired, some lawyer's going to say, well, that's the reason you fired them. That's retaliation. So you're going to have to really document. Somebody mentioned about at will. Yeah, we're an at will state, but you need to document why you're terminating somebody, because they're going to come in and say, you fired me because I'm this race, I'm this gender orientation, because I made a complaint. They're going to have all these reasons. So you got to really be well documented. So that's a big one. Employees complain. Immigration stuff. There's actually a federal, the Senate passed an immigration bill. The Senate passed an immigration bill which provides for, what are they called? Registered provisional immigrants. Okay, the House hasn't passed it, but this is not a green card. This is the people, the 11, 12 million people that are here. You have to meet certain tests. You've got to pay any taxes, fines. You've got to register. You're a registered provisional immigrant. And you can work with that. You can work legally. And for 6 years, at the end of 6 years, you renew it again. And once you've been doing that for 10 years, you get a green card. And then 3 more years, you get to apply for citizenship. So the House hasn't passed that yet. We'll see what happens. That's federal. But California is very protective of our immigrants. And there's an interesting lot of new laws now. We have a new law about retaliation and unfair immigration practices. Actually becomes a crime. So it's a serious matter. So effective this year, there's a new cause of action. Somebody can sue you for unfair immigration practice. And an unfair immigration practice is, for example, requiring more documents than the I-9 does. Not honoring documents that appear to be valid on their face. Using E-Verify. I don't know if you've heard of E-Verify, but that's a system. Just using that is a violation. Interestingly, the federal law actually requires employers to use E-Verify. So right now, in the state of California, if you use E-Verify, that is an unfair immigration practice. Any kind of threats to file a police report, call immigration, ICE, turn them in, or anybody in their family is a violation. So that those all become, and they can be protected, they can sue. And basically there's a presumption. If an employee, any adverse action within 90 days of exercising a protected right, if an immigrant says, I don't think you're paying me right, they exercise any rights under the labor code, if you take any adverse action against them within 90 days, after that there's a presumption that you did an unfair immigration practice. They retaliated against them for that. So there's special stuff for immigrants, which is interesting. And this is also kind of amazing. Yes, question?
E-Verify, if you're a federal contractor, you're usually required to use that. So is that the one place that you're okay?
Say that again?
If you're a federal contractor or subcontractor, you're usually required to use E-Verify.
Yes. Yes, federal, yes. Yes. The federal government does still, yes, they require it. And there's exceptions for that. Good point. Okay, this is interesting. This is a little scary, but right now, if the labor commissioner or a court believes that you threatened somebody, you say, I'm going to report you to immigration, I'm going to call the police, I'm going to turn your mother in, I'm going to do these kinds of things, because an employee uses any of their rights under the labor code, government code, or civil code. They exercise any of their rights. You make any kind of threats about that, you actually can lose your license. If you're licensed under the Business Professions Code, you have a business license to operate your business. Accountants, contractors, hairdressers, realtors, insurance people, all covered by the Business Professions Code, they can revoke your license. Put you out of business if you made those threats. Okay? That they take it very seriously. In fact, lawyers can actually be disbarred if they make any threats to any party in a lawsuit or a witness that, hey, I'm going to turn you in. They get disbarred.
In hiring an employee, can you ask to see their papers?
You get an I-9, whatever the I-9 asks for, and they have very clear things that you can get, that's all you can ask for. And if it looks like valid, even though you think to yourself this can't be real, but it looks real, then you got to accept it. Okay? So that's pretty tricky. So you lose your license. Now, what's interesting is the labor commissioner, that's a new power the labor commissioner has. They didn't have that power before. The labor commissioner can revoke your license or suspend it, but they take into account what's the impact on your employees. Obviously, that's bad if you're out of business. And also, did you take any corrective actions after you got a notice of this violation? So it's very important if you get a notice from the labor commissioner that you violated this law, because you made a threat, you take corrective actions, you just do whatever you have to do, and we can help you do that, then they will not likely suspend your license. Okay, really, they just want you to not do this. They don't want to be that punitive. So that's kind of interesting. If you also, threatening to report somebody to immigration or anybody in their family is now a serious crime. Extortion. Extortion is a serious crime in this state. So even the slip of the tongue, your managers, one of the things you need to do is training, your managers, what to say, what not to say, what retaliation means, what adverse action means, because your manager may think they're just, talking off the top of their cuff, they're not, there's no retaliation here. They got to be trained. What to say, what not to say, because you're liable for that. So that's serious stuff. Yeah.
Well, then wouldn't asking for an I-9 form be a threat?
No, you say, I know, you have to be able to show that you have the ability to work, which means you got to either show a passport or a driver's license, Social Security. There's like a list A and a column B, and you got to pick from each of those. So those you ask for. If they don't have those, you don't have to hire them. We're going to have, by 2015 or sooner, undocumented aliens here in California can get a driver's license. Okay? Very controversial, but that's the law. They get a driver's license. Same, because it's better that they drive, and they have a license. You know who they are. Their license can't be used for identification, can't be used as an I-9 thing, it can't be used for certain things, and it's going to have a DP on it number instead of a DL. But it can be used for work, but it can't be used for other certain kind of identifications. So it's kind of interesting. It'll have a limited, and it'll say on there that it's kind of limited what it can be used for. Yeah. Okay, that's cool. So yeah, that's going to be new. And we'll have it even sooner before 2015. But the DMV has all kind of regulations now to come up with how we're going to do this, and what we're going to say, and what kind of tests we're going to give, and they have to have rules. Okay, so now Ted's going to talk about more commissioner rights.
So I'm just going to now kind of quickly go through some new statutes that are in place. The first is AB 1386. This gives the labor commissioner a new right that if the labor commissioner finds that you violated a wage and hour practice and you have been, the employee has been awarded damages or a penalty, the labor commissioner can now lien your real property. All they have to do is file their order with the fine and submit that, and that is now recorded as a lien against your real estate. So obviously, as we tend to advise employers anyway, especially if you own a business, don't hold the real estate in the name of the business. Hold the real estate in a separate LLC. It's not a good idea to keep your real estate in your business corporation's name anyway, but now this is even one more reason why you really don't want your corporation to hold your real estate, because it can be liened for wage and hour violation. This is probably the most common question we get asked when one of our clients gets sued by an employee. Well, if I win, don't I get my attorney's fees? No, you don't. And that was the rule until SB 462. It used to always be only one way. If the employee wins the lawsuit, the employee gets all his attorney's fees. But if the employer wins the lawsuit, oops, sorry, you brought a bad case, the employee brought a bad case, the employer had to spend $300,000 or $400,000 defending it, you're out of luck. Now, a little bone to the employer that if you are able to show that the lawsuit that the employee brought was in bad faith, you get your attorney's fees. I say it's a little bone because it's really hard to show that the lawsuit was brought in bad faith. But at least now there's a little light potentially that if you win, you could get your attorney's fees. Another criminal law, another criminal penalty that's now imposed on employers, SB 390, if you fail to remit withholding, the state and federal tax withholding, that is a crime. That is now a crime. And, FEHA. FEHA was actually was amended starting January 1, 14 to provide that, you know how we have this list of all the protected classes? Race, gender, sexual orientation, gender identity, gender expression, disability, all these things now are protected classes. Well, now there's a new one, veterans. Veterans status is now a protected class, a specifically protected class. So you cannot discriminate, etc., based on someone's veteran or military status. Now, the law does allow you, so normally you cannot ask about protected classes, right? You can't ask about gender and marital status and genetic information. But there is an exception that if you are asking about someone's veteran status for the purpose of promoting a program where you want to hire veterans, then you can't ask about veteran status. But veteran status is now a specifically protected category. SB 292. This is a new law that actually reverses a case that we talked about last year. That case, which was Kelly versus the Conoco Company, said that if an employee sues for sexual harassment, but that the sexual harassment, and this is in same-sex harassment, wasn't motivated by a sexual desire, then it's not sexual harassment. So in that case, the worker was constantly being harassed by, it was a male, constantly being harassed in a sexual way by another male worker. But this was really more of like a machismo, bullying kind of thing. And the employer was able to demonstrate that this other employee was straight, had no sexual desires towards this other employee. So this can't be sexual harassment. There was no sexual intent. And that case has now been overturned. The legislature did not like that decision. So the legislature now says that same-sex harassment does not have to be sexually motivated. So it's very important that you look at what is this person actually saying, not what is their intent. You don't look at the intent of the speaker, you look at the actual words. If you're calling people derogatory names, making lewd and sexual comments, doesn't matter that it's not sexually motivated. That's still considered sexual harassment. So be very, very careful scrutinizing and training your supervisors about what is not appropriate. I mean, this obviously shouldn't be happening anyway, but now it's very clear that that will be sexual harassment.
One of the things you're required to do if you have 50 or more employees, of course, is sexual harassment prevention training. And we are more than happy to do that for you. We have a program that we do that. We recommend it even if you have 15 or 20 employees. It's really a very pro-employer law because by having this training, you limit the damages substantially and you explain to employees what their rights are, what they can do, and the supervisors. So it's a good thing to do, to have those training programs. This is interesting new laws, again, for whistleblowers. The law has been in California, Whistleblower Protections, for those, if you made a complaint to a federal or state agency about a potential federal or state violation, you were protected from retaliation as a whistleblower. This has been changed now for a couple of ways. One is internal complaints gives you protection from whistleblowing, from retaliation for whistleblowing. So if you tell a supervisor or anyone who has basically supervisory powers over you, somebody you answer to about some violations, you are now protected from retaliation as a whistleblower. And it used to be just federal or state law violations. Now it's local as well. So there's all kinds of local ordinances, special districts, and if your employer thinks it's violating one of those and you tell your supervisor, you now are protected from retaliation because of that. That's going to open up a floodgate of suits, isn't it? Because somebody makes any complaint about something and they have to just have a reasonable belief. They don't have to be right that you are violating the law. They have to have a reasonable, honest belief that there's some violation going on and they complain about it. Then any adverse action taken against them, they might claim, hey, you retaliated me because I made this complaint, which is kind of interesting. So those are two major changes, which is kind of scary. Let go here. Okay. Wait, there was another whistle. What happened here? Out of Prezi here. Oh, also, you can't adopt any policies that prohibit, in any way restrict or restrain anybody from making complaints. So it's who would have a policy that would say that? But you can't do anything like that. Also, so you have to have a policy. Also, interestingly, you've heard of Sarbanes-Oxley. Sarbanes-Oxley federal law deals with publicly traded companies. Actually, a couple provisions deal with all companies, and one is whistleblowing. So if somebody makes a complaint to a federal agency about the company, what they're doing, to a federal agency, and you retaliate against them, it's actually a federal crime, 10 years in prison. Very serious. One of the things we strongly recommend is you have whistleblowing policies. And now even for California, it's great to have policies, complaint procedures, so that you nip things in the bud. And then to train managers and supervisors on what it means to do retaliation, adverse action, and what happens if you get a complaint. Those are very, very important now. Also, now we have anticipatory retaliation. This absolutely makes no sense to me at all. Any adverse action, it used to be, all these statutes talk about adverse action. They used to be discharge, termination, demotion. Now it's adverse action. Adverse action might be, hey, we all used to go to lunch together, and now you're not going with us. Now, who knows what adverse employment action is? It's something that affects your employment. It's not good. If you retaliate against an employee because you believe that employee has disclosed or may disclose something, that is whistleblower protection. So that means any employee who has knowledge of some violation and gets retaliated against, they'll say, you fired me, you demoted me, you disciplined me because you were afraid I might turn you in. How about that? Okay? They don't even have to actually do it. So that's going to open up a lot. I mean, you can imagine. That's why severance agreements might become more and more important. Okay, discrimination for taking crime leave victims. You can't discriminate against an employee or retaliate against an employee who's a victim of certain crimes. And there's a whole list of certain crimes, serious crimes against that person, for taking time off to go to appear in court or to get temporary restraining orders. You can't discriminate. The employee is supposed to give you notice. I'm going to be gone for 2 days, they have to go to court or something like that. But if they don't give you notice, just an unexcused absence, they just don't show up for 3 days, you have to give them a chance. And then they come back and they say, well, I had to go to court or I had to deal with the police. You've got to give them a reasonable time to bring you proof of that. Even an unexcused absence, even if that's your policy, that we don't, you're fired if you don't tell us you're not coming in, you have to give special allowance for that. So for crime victims, special rights. New law, we've always had protection against people for being retaliated against or being in any way discriminated because they are the subject of domestic violence. Employers would say, the husband would keep calling, would show up, it'd be a mess. They'd say, I don't want to deal with this, we're not going to keep you. They've been protected. Okay, you can't discriminate anybody because they're the victims of sexual assault or domestic violence. We now include stalking. And stalking you can buy by the internet, stalking can be by people just putting notes on your car, it can be by following you, it can be by calling you. Stalking is a very broad term. Stalking is now protected. You can't retaliate or take any adverse action about somebody who is stalked as opposed to anything else. And if the employee, and you don't have to be told that they're the subject of this. If you know, just because you've listened, you've talked, you read the papers, whatever, that they have been the subject of a domestic violence or stalking, then you can't do any discrimination or retaliation against them. Again, if you do, they're going to claim that's why. You also, if they come to you and say, I'm being stalked, I'm concerned, you need to make reasonable accommodation, and you've got to do this interactive process like with disability. What can we do to help you? Might mean closer parking space, changing your workstation, changing your hours, changing your phone number, changing the facility somehow, maybe getting a security guard. As long as it's not an undue burden, and that's going to be an issue. What an undue burden is, you have to make reasonable efforts to help them. If you have 25 or more employees, you have to allow that employee who's a victim of stalking, domestic violence, sexual abuse, to take time off to deal with medical, psychological issues, or safety planning. They're not disabled. I'm not going to see a doctor because they're disabled, but they're having psychological issues with the sexual abuse or the stalking, or they go to safety planning. There's all kinds of organizations that help, particularly women, to avoid these kinds of things. You've got to give them time off for that. So again, very important to have policies in place that help with this. Okay? And the last one here is paid family leave. You're all well with that. That's employees. You can get wage replacement benefits if you're an employee to go take care of certain family members. What's interesting, it doesn't cost the employer any money. That comes out of the paycheck, and the employees are paying into that. Fine, they get money. It doesn't guarantee them a job back. Unlike most of these other leaves, pregnancy, disability, other kind of leaves, you got to kind of keep their jobs open and watch that. Here you don't. If they talk about paid family leave, that doesn't guarantee them a job when they come back. Most people provide it for them when they come back, but it now covers more people. It used to just cover spouses, parents, or child. I'm going to take time off to take care of my family, my spouse, whatever, my baby. The government will pay you. Now it's grandparent, grandchild, sibling, and parents-in-law. You can actually get these benefits. You get up to like $800 a week, depending on how much you earn for paid family leave. So you just be kind of aware of that. And there's certain notices you got to give people when they want to take paid family leave and so on. So, are there questions? You have a question?
Does the employer get any rights against employees discriminating against us?
No.
Well, and that's a good question. The question was, does the employer have rights against the employee discriminating against the employer? Particularly for public employers, government employers. There was some recent cases about Facebook. There was a sheriff's election. I think it was sheriff. And the employees in the sheriff's department all put on Facebook that they clicked like for the opponent, the sheriff's opponent in the election. And when that opponent lost and the sheriff won, those employees were fired. Because he said, well, you were discriminating against me for liking my opponent on Facebook. Well, that was not, no. The court said that clicking like on Facebook is free speech. And particularly in the government context, there's extra protections there. And the employees argued, well, that's not free speech because it's just a like on Facebook. Well, the court actually said that a like on Facebook is no different than putting a campaign sign on your front lawn. So that's a whole new area. You've got to let employees express themselves, even if it's something that's bad about you.
Another question. With regard to your Facebook topic, you mentioned earlier that an employer should not be necessarily looking on Facebook as a preliminary factor prior to interviewing a prospective interviewee. How difficult is it for a plaintiff's attorney to do the discovery and get the electronic discovery? In other words, how vulnerable are our laptops as targets of discovery, and what does the other side have to do in order to get into our laptops?
Well, once there's a lawsuit, you get a notice from the plaintiff's lawyer you can't basically delete, destroy, or get rid of any evidence. And that means your cell phone records, your laptops, anything that you've used in your business at all, you cannot delete, erase, or change anything on it. And they can get court orders if they have to, or subpoena, all those things, and have experts go through it all.
Is it only after a court order is issued that kind of discovery is allowed?
Generally, yeah. So it's kind of interesting.
Please help me thank Schroeder Associates again for a great program. Is it just getting more confusing, Roy? Because the room grows every year. I think as the legislators are working hard to keep us on our toes. But we really do appreciate providing these seminars and these programs. We have the new employment posters and other materials in the back if you'd like them. And it's just been great having you. So on behalf of the Ventura Chamber, thank you all very much.